Hello, my name is Dreux. I am a student in the University of Groningen, currently studying in the LLB program and as a part of Working Group 2.1. Today I am submitting to you this short vlog wherein I will analyze the case opposing Jani Makraduli versus the former Yugoslav Republic of Macedonia. In this vlog I will take a look at the boundaries of defamation as well as an insight on freedom of expression in Europe. And I will do so by analyzing the relevant facts of the case, the court's proceedings, the question of law, and finally the concurring opinion of the judge, as well as my opinion on the whole case. So, to start with the relevant facts. The relevant facts of this case are that there are two applications. The applicant is Jani Makraduli against the former Yugoslav Republic of Macedonia. Jani Makraduli is the vice president of SDMS and he is a political opponent of the ruling party at the time of the events. The events first took place in 2007 when Jani Makraduli, on a live broadcasted TV press conference, accused Mr. SM, who is the Prime Minister's cousin, who at the head of the ruling party at the time, of misusing police wiretapping powers in order to gain advantage on the stock market. So in 2007, he made this accusation on live television and was taken to court for libel in 2011. The second case is a similar case. It's Jani Makraduli, once again in a live broadcast TV press conference, accusing Mr. SM of being involved in the sale of public land for the building of a private hotel. And he was once again taken to court for libel and defamation and once again found guilty. So the court proceedings for this case are as follows. Mr. SM brought proceedings to the applicant for libel, punishable under Article 172, Section 1. During the court's proceedings, there were 12 hearings that were set by the Skopje Court of First Instance. On November 3rd of 2009, the Court of First Instance found Mr. Makraduli guilty of defamation, handing him out a fine of 1,500 euros with 75 days of imprisonment. On the 11th of May 2010, the Skopje Court of Appeal upheld the trial court's judgment, dismissing the applicant's appeal to the Court of First Instance, and therefore dismissing his appeal. The applicant then filed a constitutional appeal to the Constitutional Court of the former Yugoslav Republic of Macedonia, and on the 23rd of February, the Constitutional Court dismissed the applicant's appeal. Following this, the applicant lodged an appeal with the European Courts of Human Rights. Now, the question of law in this case is the following. Do the criminal convictions for defamation constitute a violation of the right to freedom of expression under Article 10 of the European Courts of Human Rights? And moreover, do the convictions constitute an interference with the right to freedom of expression within Article 10, Paragraph 1 of the European Courts of Human Rights? And if so, can the interference be justified under Article 10, Paragraph 2 of the European Courts of Human Rights? To answer this, the court used two questions to answer to proceed with their judgment. Was this decision prescribed by law, and did it serve a legitimate aim? They found that yes, there was an interference, which was the common ground between parties, and that the interference may be justified under Article 10, Paragraph 2 of the European Courts of Human Rights, as it is prescribed by law under Article 172 CC, and that it did serve the legitimate aim, the protection of Mr. SM's reputation. We will now look at the concurring opinion of the judge in this case. The distinction between facts, in his opinion, the distinction between facts and value judgments is not that relevant according to paragraph 2 of his judgment. The fact that the applicant made the remarks on behalf of a political party is irrelevant in the viewpoint of the proportionality analysis, which he states in paragraph 6, and he disagrees with the approach regarding the applicant's reference to rumors in paragraph 7. He therefore disagrees with the reasoning that freedom of speech is broader for politicians than that of commoners, which we can see in paragraph 8 and 9. Now, I will give my own opinion on this case, and we'll look at the fact, was it necessary in a democratic society to make this judgment and to sanction Mr. Makraduli as such? Firstly, I will look at the applicant's position, and then secondly at the plaintiff's position, and then take an insight into each application individually. So the applicant's position, he made those remarks as a member of parliament in a political context on behalf of a party, the SDMS. And freedom of expression for members of parliament is political speech par excellence. On the other hand, on the plaintiff's position, Mr. SM was a high-ranking state official, which means that limits of acceptable criticism are wider for state officials than for private individuals. A politician is inevitably and knowingly lays himself open to close scrutiny of his every word and deed, and therefore must display a greater degree of tolerance. Moreover, the requirements of the protection of his reputation has to be weighed against the interests of an open discussion of political issues. I will now look at application 1 and 2 and give my interpretation and concurring opinion on both cases. So for application 1, the statement about his financial gain was based on Mr. SM's own declaration of statements, which the court found as sufficient factual ground. The statement about the wiretapping were based on public rumors which have become stronger, and the applicant just put matters up for public debate, which is the whole point of a press conference, which was exactly his role as a politician. Having to prove his statement is unreasonable, if not impossible, though. In the second application, the statement was based on research done by the political party, and the statement did not contain insulting language. The remarks were inadmissible, in my opinion, and it was not justified to demand more than the standard of due diligence. So, was it necessary in a democratic society? In my opinion, both statements were fair comments on issues of legitimate public interests. They were made only so the applicant had no possibility to reformulate, and in my opinion, fines have a chilling effect on the political debate because they automatically incriminate the opposition, therefore decredibilizing their beliefs and their attempts to become the ruling party. And following this, Macedonia has decriminalized defamation. So in my opinion, the domestic court failed to strike a fair balance. There was disproportionate interference, and in conclusion, interference is not necessary in a democratic society, as freedom of speech is a basic human right and should be granted to anybody, even in a political situation. So, do these convictions constitute a violation of the right of freedom of expression under Article 10 of the European Court of Human Rights? In my opinions, they do. If so, can the interference be justified under Article 10, Paragraph 2 of the Convention? No, as, in my opinion, once again, interference is not necessary in a democratic society, as debate is an important part of political aspects and it must be taken into consideration. If Mr. Makraduli had a legitimate belief in what his accusations were about, and if the research done was sufficient, which in this case I believe it was, as the evidence was from a research made by the political party of the SDMS, and from Mr. SM's financial assets. To conclude, I would like to thank you for coming and watching this vlog today. I hope that you enjoyed it and it was interesting for you. I would like to say that I had a lot of pleasure analyzing this case, as criminal law is the main aspect of law that interests me and in which I would like to work beyond my studies. And I hope that my work was sufficient and up to your standards. And I wish you an excellent year. Thank you very much.